Good morning, everybody. Welcome to the Social Housing Roundtable. Lovely to have you with us today. Massive thanks to everyone who's been able to join us. I know it's a bit chillier today, but as I say, big welcome. My name's Matt Baird. I've been running this platform now for the last 4.5 years. The idea behind it is to bring together voices from all manner of different sectors and all manners of different areas to come together and have a really informed discussion. We encourage debate, we encourage disagreement, obviously respectfully, but the idea behind this is to hear from something outside of our own echo chamber, to hear different points of view, and to really embrace that idea behind actually if we do converse and do talk about things in a different way and hear from people from different walks of life, then hopefully true change can be made. Day to day, I work in recruitment. That's what I've done for the last 14 years. Is one of the strings which keeps the Social Housing Roundtable running for free. So thank you to everyone who's utilised myself and Avalon for our recruitment needs. If you are looking for recruitment support, please reach out. But we also wouldn't be where we are without our sponsors. So annually, we are sponsored by the brilliant teams at both CMSG and Alertical. And we also have individual sponsors. So a huge thank you to Devonshire's who have sponsored a series through this year, this being one of those sessions. And we've got Kirsty Thompson with us today, who's going to be leading on today's session. I'm also joined, as some of you may or may not recognise, by Elaine Middleton. Elaine is running things for me in the background today. She's going to start taking over on the occasional session just for a little while I've got other things going on. I'm away on annual leave next week, and I've got a little. We've got another conference coming up in a few weeks, so Elaine is going to be running those sessions. So do please give her as much support as you've always given me. And Elaine is running things in the background today. But on to today's session. So, as I say, Devonshire's have come forth, they've run a few sessions for us. They're always really highly informative. And when we're trying to work out what to put together, we're trying to cover an area that at the time we hadn't covered. We then, about a couple of months ago, we had a session which a couple of people dropped out of, and we had the brilliant teams from both Avalon and various other businesses come together and talk about some of those challenges regarding recruitment of ex-offenders and where we are maybe socially and politically with some of those points. Kirsty is coming on today to talk very much about the legal considerations when inquiring about criminal records. What can we say? What can't we say? And then diving into things a bit deeper for us as well. So I'm going to pass over to Kirsty to introduce herself, to bring forward to today's topic. If you are new, please feel free that while Kirsty's sharing her ideas and thoughts, put points in the chat, put thoughts, ideas, questions, whatever you like, and we can bring those in. But once Kirsty has had her 15, 20 minutes, depending on how long, Kirsty, I'm going to put the litmus paper on you for today, the light on you for. We will then open it to a more wide discussion where everyone is welcome to dive in. So without further ado, Kirsty, a huge welcome today, and thank you for joining us.
Thanks very much, Matt, and thank you all for the opportunity to be here. So as Matt said, I'm slightly pivoting my session from the original plan in light of the more recent session that there was, which obviously was talking to you guys and encouraging you to think about kind of the recruitment of ex-offenders from a perspective of being less risk averse and being more kind of, if the sector wants to demonstrate a commitment to embedding lived experience, then should the sector be more open to the recruitment of job applicants with a criminal record. So say slightly pivoting this session, I think still within that kind of broad theme of can and should the sector do more in this space, but pivoting it today to look specifically at the kind of legal framework that exists in this area. And I think the first point that's kind of worth noting is that many employers, including social landlords, will in all likelihood be employing people with criminal records already and just not realise it. And that's because in the employment sphere, we have a distinction between what we call spent and unspent convictions. And if you have a spent conviction, then you are perfectly entitled for most jobs that you apply for. When asked the question, do you have a criminal record? The individual is perfectly entitled to say, no, I don't. So once a conviction is spent, then for most roles, it never has to be disclosed, and the individual can't be held to account or held liable for not mentioning it. So that would mean that for most roles, as I say, there could well be people with a criminal record history who are employed perfectly happily, no issues, and nobody is any the wiser. And the law specifically allows for that. There is then a kind of a subset of roles, which, as you might anticipate, kind of involving working with vulnerable adults, including working with children, where that distinction between spent and unspent convictions is kind of less black and white, and the employer is in fact entitled to know about spent as well as unspent convictions. What we tend to find in that space is, say, kind of the distinction is kind of principally driven by what does the role entail? What is that person going to have the ability to do? What sort of people are they going to be working with? Particularly in the social housing sector, I think it's worth noting that we do tend to see, and this kind of links in with the point on the previous session about kind of the risk averse nature, or the kind of risk averse perspective that's adopted here. We do tend to see employers seeking to do more checks than they actually should. So as I say, there's spent and unspent convictions, and you are allowed to ask about both spent and unspent convictions in certain roles, but not in half as many roles as we tend to find employers would like. And one particular pinch point that we do see is that for individuals who will be going out into tenant properties, so repairs staff, for example, we have a tendency to see employers want to do much more stringent checking of somebody's criminal record history than actually they are legally entitled to. So I think possibly that's something for some people may want to think about in terms of whether their risk aversion to this is kind of pushing them into a territory where they're doing checks that they shouldn't be. But if we then step the kind of the legal context on to where there is an applicant applying for a role who does have a known criminal record history, so either they have unspent convictions and therefore an employer isn't perfectly entitled to know about them, or they have spent convictions and they're applying for a role where the employer is entitled to know about those. So kind of taking that parameter. Actually, the individual applicant has very little legal protection when they're applying for a role. So you'll all be familiar with kind of the concepts of discrimination that exist under the Equality Act. There is no protected characteristic or equivalent of a protected characteristic that applies in relation to criminal record or kind of previous criminal convictions. And if you're just applying for a job, so you have no length of service, you also have no rights to bring any sort of unfair dismissal claim if you're rejected from that recruitment process because of your disclosure of convictions. So the individual, say, has very limited legal rights. I think that possibly then partly feeds into employers feeling more comfortable taking quite a hard line of saying, well, if you've got a criminal record, we don't want to employ you, because they know that there's very little that the individual who misses out on an opportunity as a result can do about that. But that said, what I would encourage employers, or what employers should be doing in this space, is not having a blanket ban that if somebody has a criminal conviction, that means they cannot be employed by you or by the landlord. What should happen is a case-by-case, risk-assessed decision about the person who has applied for a role and disclosed convictions. And we would typically expect that to look at how long ago was the offence committed, how old was the person at the time it was committed, how have their circumstances changed, because a lot of that can kind of tell you a lot about kind of the likelihood of an individual reoffending whilst they've become employed by you. So a risk assessment process on a case-by-case basis is the kind of the history of the applicant that's coming for you and the nature of the job that they are applying to you for, and kind of looking at that bigger picture and making individualized decisions. The concern that we commonly see, or that I commonly see in what I've been practicing now for nearly 20 years in the employment law space, so fair few cases have come across my my desk in that time. And the concern that I would commonly see is, I guess, twofold. One, the employer is concerned about the reputational risk of knowingly employing somebody with a criminal record, and at the same time they can also be concerned about, well, if I employ this person knowing they have a criminal record and then they reoffend whilst employed by me, then could we, the organization, be liable for the actions of one of our employees whilst employed by us? So those tend to be the kind of two common concerns that we see. And I think there's kind of some relevant points to draw out about kind of where those concerns come from and how valid they are, and really kind of how qualified employers are to make that judgment. And I think partly the fact that an employer doesn't really feel able to grapple with the likelihood of somebody reoffending is what tends them towards this more risk-averse approach of, well, we won't employ you. We can't assess the likelihood of somebody reoffending whilst employed by us, so we won't take the risk that they might reoffend, and we will just not offer them employment in the first place. Kind of all feeds in together. But I was just looking at some statistics for the purposes of prepping for this session, and actually from a statistical perspective, and I know people say you can find statistics that tell you whatever you want to look for, but the prospect of somebody reoffending whilst in work at the last government measure was 16.8%, so 17% prospect of reoffending whilst in work. As I say, the other angle that we tend to find clients concerned about is this reputational risk. I tend to find that's higher in local and community-based organisations, where they feel it's more likely that residents will just happen to know that a particular employee does have a criminal record because it's locally known on the estates or whatever the case may be. So I do tend to see that kind of reputational risk heightened amongst the kind of local community-based organisations. And it does have to be a relevant consideration. And I am aware of one case involving a social landlord where it was actually the employee of a contractor who had a criminal record. So social landlord sends out contractor to do a particular job for a resident. Landlord unaware of the criminal record history of the person on the ground who's sent out by the contractor to do their job, but the resident knew that they had a criminal record. And the resident then complained to the landlord about the fact that somebody with a criminal record had been sent out to their property to do a particular job. So there can be these reputational considerations, particularly where you're recruiting ex-offenders into roles that will involve accessing people's properties. The kind of considerations might be slightly different if you were employing somebody to work in an office-based job in finance, for example, as opposed to kind of sending somebody out into somebody's homes where the kind of customer angle, the customer perspective might be perceived very, very differently. The current government minister for prisons and probations is Lord Timpson, of the Timpson's shoe shop and key cutting business chain. He, even before this job, and kind of partly what kind of the government felt qualified him for the position he's got now, is his organisation and he himself are really personally invested in the idea of recruiting ex-offenders. 1 in 10 employees at Timpson's is somebody with a criminal record. They've made it a big kind of part of their mission, if you like. And I was reading something that said that the public think that actually that's very positive for social good, that Timpsons have that approach, that model to employment. But I think you can see, or I think you can anticipate seeing a kind of a difference between, I think it's very laudable that I can take my shoes to be rehealed in someone's shop, and it might be a former thief who is rehealing my shoes, versus knowing that a former thief has gone into my elderly relative's home in order to fix a leak. I think you can think that the public perception of how positive and good that societal aim is different in that scenario, and that does play into that customer kind of perception issue, which, as I say, I think in turn informs the risk appetite that social landlords are willing to step into in this space. And the third point that I kind of just wanted to kind of put out there in this kind of scene setting thing before we go into discussion, and I have seen a few questions pop up, which I'm sure Matt will kind of talk me through or give me an opportunity to read in a second. But the third kind of thing that I wanted to put into the debate is the possibility of maybe whether there will be some future political change in this area. As I mentioned, Lord Timpson has been appointed by Keir Starmer to be the Minister for Prisons and Probation. He obviously comes from a background which is very pro the employment of ex-offenders. There's already been a lot of kind of content pushed out through the Department of Justice about kind of positive campaigning that the Department of Justice and Lord Timpson are doing with various kind of well-known employers around really encouraging and kind of setting up positive initiatives around the recruitment of ex-offenders. But I think it's not impossible that we might see another step change in kind of the legal framework around the recruitment of ex-offenders. So in like 2012, we saw a big narrowing in the sorts of roles that you could do kind of those more higher level criminal record checks on, and say that kind of pared it down to really just roles that involved working with vulnerable adults or children. And whether there is the potential that with Lord Timpson at the helm driving this, there might be a further paring back of when you can do criminal records checks, or possibly a further kind of reduction in how long it takes a conviction to pass from being unspent to spent, as part of kind of driving this change and kind of mindset change in relation to the recruitment of ex-offenders. So that's kind of the three legal highlights isn't quite the right word, the three legal elements that I wanted to draw through. But as I say, Matt, I did see questions pop in.
Absolutely, and thank you. I think it's vital that we look at these from a legal perspective, because sometimes it's very easy to talk about wouldn't it be nice, and wouldn't it be nice, and wouldn't it be lovely? But we sometimes go, well, legally we can, and legally we can't do that. Just before we do, I just wanted to double back to something you were mentioning before around the complaint that was raised by a tenant who had somebody enter their home with a criminal conviction. They hadn't been made aware beforehand, but they'd obviously found out either during or after the process. Was that complaint upheld? Do you know what is, from a landlord's perspective, what is their legal obligation in that situation? If a business has verified their employment, has decided that they are somebody they want to employ, does a tenant have a legal right to say, I don't want that person in my home? Or is that in some way classed as discriminatory? How does it work in that space, just from a complaints perspective? Just an interesting, if you had a follow-up to it. Case Management Solution Group, or CMSG, are the home of React, the UK's #1 case management system for ASB and community safety. We are delighted to have them as one of our key sponsors for Social Housing Roundtable 2025 into 2026. And with the ASB app now fully integrated to the platform, it allows residents to record, monitor and report issues directly to their case office in live time. What's not to love? CMSG are bringing simplicity back to case management, and I cannot recommend them enough and thank them for all of their support through this period and through the rest of the year. Thank you, CMSG, and do please go check them out on social media and on LinkedIn. Thank you.
Yeah, so in this case, the landlord in question didn't know. They've since put in place new protocols with their contractors so that they have more kind of control's not quite the right word, but kind of more, they expect more of their contractors in terms of what their contractors do vis-a-vis their employees. So in this case, the landlord didn't know in advance of sending this particular or kind of tasking this particular contractor with going to do this particular job. I don't know whether the tenant knew from the beginning of the appointment, kind of just because they happened to know this person because they had a reputation or whatever the case may be, or whether they found out subsequently. But they did raise a complaint kind of through the landlord's complaints process, and I think there was some form of apology given that it had happened. But as I say, it's kind of, in a sense, it was out with the landlord's control because they didn't know in the first place. In terms of the ability to say, no, I refuse entry to X person because I know of their criminal history, I'm probably going to say you need to ask a housing management lawyer, not an employment lawyer on that one. I suspect, I mean that there wouldn't be a discrimination angle because, as I say, there isn't any particular Equality Act or other protected characteristic that attaches to kind of criminal, to someone with a criminal records history. So I imagine it would come down to kind of rights of access of landlords, operatives, and whether there is a right to reasonably refuse access, which I guess would apply across the board, not just because of a criminal records history that a resident might have with a particular individual attending. So I might have to pass on that one rather than promulgate information that I don't actually know to be true across a podcast forum.
No, look, absolutely fine. I think it's just an interesting, like, I completely understand the tenant's perspective, saying, look, I know this person in the background and I'm wary, but if the employer has already done a safeguarding check and they believe this person's employable, it's a difficult one. And I was just interested whether the complaint was upheld, but anything we find out later is great, and we can obviously talk about that at another time. One of the questions that come through from Grant, I will just say to everybody who's listening, if you would like to dive in, either feel free to put a question in the chat, as both Grant and Ijaz have done, or use the React symbol at the bottom of your screen and raise hand, and we'll absolutely bring you in. We're more than welcome to hear from anybody. Grant has said, hi, Kirsty, you mentioned we should look at age of offence and conviction, time spent, and if it's spent, what is the timescale of when the offence and time spent occurred? Is it 2 years, 5 years before you can consider? And it ties in with Ijaz's point of, would the spent or unspent conviction show up on the DBS enhanced disclosure? Because I think it's worth noting there are two different types of DBS checks as well, aren't there?
Well, in fact, there's three and a half. So we have a basic DBS check, which you can do on any role whatsoever, so regardless of its nature, but that will only show you unspent convictions. There is then a standard check, which tends to be more kind of around regulatory stuff. So for example, when I qualified as a lawyer, I had to have a standard, wasn't DBS then, it was CRB check. Back then I had to have a standard CRB check done when I qualified to be a lawyer, and you also see it kind of at point of qualification for maybe accountants and things like that. And then you have an enhanced level check, and the enhanced level check gives you unspent convictions, spent convictions, and what colloquially used to be known as brown envelope information, which is kind of, you've not been convicted of something, but the police have got some nagging concern, let's say, and that kind of goes in this brown envelope of information. And then you have, I said 3 and a half. The half is what we also have as barred list checks. So there are some occupations where you can be put on a list which says you absolutely cannot be employed in this particular field. So teachers, for example. So we have those levels of checks. And in terms of that, so the second question that came in about, so an enhanced check would show you spent and unspent convictions. A basic check would only show you unspent convictions. And in terms of where is that line between spent and unspent, or when does a conviction become spent, it depends upon, typically it's driven by the length of the custodial sentence that is issued. And if it's something, if if the criminal sanction is something less than a custodial sentence, then it's kind of a fine or a caution. Then the kind of spent threshold is different. But typically, where the kind of criminal offence was penalised by a custodial sentence, then the conviction becomes spent a certain period of time after the end of the sentence. So for the sake of argument, custodial sentence of 18 months becomes spent, I think it's 4 years after the end of that 18-month period. So it's kind of done in bands depending on the duration of the custodial sentence. And it is implicit and necessary that you don't reoffend in that period. In order for your conviction to become spent, you must not reoffend within this spent unspent period. But yeah, it's driven by the severity, essentially the severity of the sanction that you received. And there are some offences, obvious example, murder, which will never become spent, just for public policy reasons.
I remember when I worked in education recruitment, certainly those, I can't remember, section 21 list? No, I can't remember, section something list. Anyway, that was the one we had to check, and that would come up with anything, like say, banned from working with children or young people. So yeah, fully recall those. But no, thank you very much for sharing those. I'm keeping an eye out for hands going up and for questions coming through. Whilst I do, I'm just checking no one's going to dive in and be brave. I know there's been a fair bit of conversation and question that I've heard from landlords, certainly from a recruitment perspective when I'm hiring with them, which is, A, can I ask whether, am I allowed to do a DBS check on this role? Is that something I'm allowed to do? And B, when can I ask? Because we don't want to be seen to be discriminating against anybody. But equally, we have safeguarding checks in place based on XYZ for ABC roles. So I guess the question is, when is it okay to ask about DBS? And are there roles in which actually, because I've got my own understanding of this, but it'd be great to hear from yours, where it's okay to ask about a DBS check and you're perfectly in line to, because actually there's some roles you're not allowed to do an enhanced DBS check for, because you're just not allowed. The DBS won't process it, will they? The business won't process the DBS check.
Yeah, so I think it's probably still, I mean, as I say, I've been at Devonshire for a very long time, so it's a long time since I've actually had to fill in an application form for a job, but I think it's probably still pretty standard that application forms include just a generic question of, do you have any unspent convictions? But and this is kind of where we slightly pivot again from employment law to more kind of information law. The Information Commissioner has a view on these sorts of questions and this sort of vetting, and they would encourage that actually that question is asked as late as possible, i.e. you would go up to the point of, this is our preferred candidate, and identifying the preferred candidate, and at that point you would be doing the checks around criminal records and asking the questions about, so asking the initial question around criminal records and then doing whatever verification you wanted to do via the DBS. Now, the operational reality is that many employers, including social landlords, don't want to get all the way to that point and then be in a stage where they're waiting for a DBS result, and possibly then that comes back and discloses something that they don't like, and then their second best candidate has moved on and found another job. So the operational reality is that employers want to check sooner, but from a Information Commissioner's perspective, certainly they would encourage checking at the latest opportunity in the process, just that you're not holding criminal records information about people that you don't need to be holding because they're not going to be progressing through the process.
And I guess from that data side, it's absolutely vital that we are then dealing with that, in terms of not storing that for future or anything along those lines, because you say things could then become unspent, particularly for, I know a number of roles, you can't have somebody as a support workers, housing officers, absolutely enhanced DBS checks. But certainly when I've recruited for people in HR or finance or IT or something like that, you can do a standard one, so you can see if there's anything unspent, but you can't see if there's anything spent because, as I say, the Information Commission won't allow you to process the DBS check and the enhanced DBS check in the first place.
Yeah, and in fact, it's probably worth mentioning that it's actually a criminal offence to knowingly try and do a check of a higher standard than you're allowed to, i.e., to try and do an enhanced check when you're not able to do so is actually a criminal offence. So employers do need to be really careful in that space, because they're just what always surprises me, and actually, Matt, your experience might be a little bit different, but what always surprises me is how many of my clients have actually been able, not realizing that they shouldn't, but how many of my clients have actually been able to do an enhanced level check on somebody like a trades operative. And really, it should be filtered out by the kind of companies that they're using for these vetting checks. But it's surprising the number of those that get through.
I've undertaken a number of DBS checks I've needed to over the years on particularly interim workers that I've placed into roles, because I mean, to those who don't know, when you employ somebody on an interim contract, you're actually employed by the agency rather than the end client. And there are different themes that you log your enhanced DBS check under, and it isn't difficult to change those. And yes, you say yes, it's definitely that, but realistically, no one's fully checking. You can kind of, and it's got more difficult, thank goodness. You know, it is. I mean, under the CRB basis, it was far easier. It's more difficult since they changed the DBS, and there are more and more checks in place, and you do get questioned more along lines of, what is this person going to be doing? I guess the pushback there might be, well, hang on, as a trades operative, they are going into vulnerable people's homes. They are working on their own. They are, we're trusting them out with all this equipment. We need to know whether or not somebody has it. But that isn't enough from an Information Commission side to go, well, that doesn't necessarily mean that this person shouldn't be employed in the role in the first place. And it's that balance that people find quite a challenge, I think.
Yeah, I think it is, particularly, as I say, with those kind of roles that involve sending somebody out, as you say, potentially sometimes on their own to be in a tenant's home. Those are the roles which I tend to find, particularly in this sector, employers are particularly anxious about from a criminal records perspective, and they always want to be doing as much kind of verification and vetting for obvious and understandable reasons. And it's not to say that they will do checks and then just dismiss somebody out of hand and say, well, they can't be taken any further forward in the process. But yeah, there is a big kind of the legal reality versus what the employers want to do don't align there, and employers don't necessarily always like it when I tell them that actually they can't take their kind of trades operatives through this much higher enhanced vetting regime, and it's kind of they have to do a basic check and live with it.
Completely agree. Brian, good to have you with us. Do please come in.
One of the things which strikes me about what you're saying, what you said earlier on about a subcontractor, being that they're doing work for the landlord, in some ways, wouldn't the landlord have that responsibility to ensure that the people going in? I'm thinking of one particular scenario of somebody who has had a domestic abuse record at some point in the past, going into a property of somebody who was a victim of domestic abuse, and that causing some sort of conflict or issue at some stage, that even a subcontractor has a responsibility to the landlord to make sure that that doesn't happen.
So probably not in such obvious terms as you might think should operate. So as a matter of law, any employer does not, in fact, have to do any DBS or kind of criminal records checks on its employees if it doesn't want to, other than, say, if you want to employ a teacher, or kind of in certain scenarios where it would be illegal because somebody's on a barred list. Actually, an employer is under no obligation to do any criminal records checks on its employees. It's kind of a voluntary in that sense. So it's difficult for a landlord to compel a contractor to do something which it's not legally required to do. As I say, in the case in question, that landlord has looked at its kind of code of conduct and protocols that it has in place with contractors to kind of beef up the expectation that the contractor will have done suitable vetting checks in relation to its employees. But you, again, the landlord can't dictate that the contractor does checks that the contractor's either kind of not legally able to do for obvious reasons, nor can it kind of enforce the knowledge, because also we have to think about kind of information pertaining to criminal records as being some really quite sensitive personal data. So contractor might well do criminal records checks on its employees and might indeed identify that an employee has a criminal record, but it might do a risk assessment and determine that actually there's no reason why that person can't be employed. It can put safeguards in place, or it considers the risk of reoffending to be really low because offence was a long time ago, whatever the case may be. But then you've got to think about, well, can that contractor legitimately pass information up to the landlord, which is very sensitive personal data relating to a particular individual? So there can kind of be, we touched on the information commissioner earlier, but there can also be kind of an issue there in terms of that information being shared up the chain. So it kind of, yeah, you might like to think that it would work as you've just described, but the law doesn't really fit that matrix.
And there's a point there made by Ted in the chat, said, do customers get told there's an ex-offender working at or in your property beforehand? It should be made mandatory that checks are made to protect tenants. And I think this is where a lot of businesses, certainly I know from Spring, for example, around the chair, we expect our board members to have had DBS checks. We expect our staff who are customer facing and out with our tenants who are support workers, we expect them to have done enhanced DBS, but that's our own onus on that, and that is us enforcing that, and then we are held by our own policies and everything else that goes with it. I guess that's where, that's that point that Ted's made there. Do customers get told there's an ex-offender working at or in your property? Well,
no.
It goes back to that point you were at before. It would be, useful to be informed sometimes, but equally that doesn't mean you're going to be, because the business might not know, particularly if they're doing subcontractors, and also the legal right isn't. There isn't a legal right to tenants to inform them, but some businesses still will.
Yeah, I think that's right. I mean, I'm certainly not aware of any landlord that would make a positive notification to its residents to say, we're sending Joe Bloggs out to fix your leaky tap, and FYI, Joe Bloggs has a criminal record history. I'm not aware of any landlord that does that. And I totally get kind of the tenant angle of why they would want to know that, but I guess I also look at it with my employment law hat on and that kind of personal data of the individual employee, because you could tell resident that Joe Bloggs is coming, but then resident tells all their friends and it's quickly spread across a whole neighborhood that Joe Bloggs has this criminal record, and maybe Joe Bloggs has done a world of effort into kind of turning their life around, etc., etc., and all of that can just be dashed through kind of the ending up of kind of spreading of essentially what becomes kind of the equivalent of Chinese whispers, where stories just kind of spiral as they get passed around. So yeah, I'm not aware of any landlord that would make a positive notification to its residents of that.
Is, I think, I appreciate we're moving on to more of a social debate, but there is often stigmatization against people who live in social housing, which is completely unjust. There's against a lot of people in society, and yet when we had our last roundtable on this, a lot of the debate that came out of it, a lot of the discussion that came out of it was actually, you know what, if you've had your conviction and you've spent your time and you've been shown that, through references, whatever it be, that you can really add to society again, then we welcome you. We want you back into the space. There's a huge pool of candidates that are there, that are desperate for work, that, as you say, less than 17% reoffend if they've got another vacancy. Too often, that's one of the big challenges, is that people can't get back into work, so they reoffend. And there's this whole piece. And yet on the other side of it, there's a thing of going, well, hang on, I'm a tenant. I don't want someone with a criminal conviction in my home. Because if they've made if there's been a if they've committed a crime once, they might commit a crime again. I don't want that person in my house, and the balance between it. Now, obviously, I'm not saying that's the same viewpoint from every tenant, nothing like it. But that balance between the two on the stigmatization side is very, very difficult. And how we balance that is very difficult. But I think the important thing is legally, there's no need to inform anybody that you're a social housing tenant, and there's no need to inform somebody you've got a criminal conviction. It just so happens to be that's where I live, and that's a conviction I have on my DPS. And if it's enhanced and it's unspent, you will find out about it. If it's not, you probably won't. I spoke to a gentleman who, not long ago, who was caught up in a very, very large drug scam. I'd worked with him as a candidate for many years before knowing anything. Before he had any kind of conviction, he was always a very, very reliable candidate. And then didn't hear from him for a few years, and he's like, "Look, I'm now on day release. This is the thing. You can Google the story. You can do X, Y, Z. Can you help me get back into work?" And despite me knowing he'd been a good candidate before, and despite me knowing all of the good work he'd done, there was a question of, okay, how is an employer going to see this if I put this person forward? Not just because, oh goodness me, they've got a criminal record, but what are they going to think of me if I put them forward and say, look, this is someone I'm advocating for, and how that would affect. And that balance is really, really challenging. But as you say, legally, I mean, his would have come up obviously, and they would have made the decision there. But it's that piece around society and maybe what we want and the stigmatization that goes with it compared to the law are two very, very different things in this argument, aren't they?
Yeah, definitely.
What would you kind of advise then to employers in this kind of space who are worried about whether they should be doing more or less in criminal convictions? Is there a right thing to do? Is there an absolute perfect way to be doing this at the moment, or is there still a little bit of grey area between the two, do you think?
I think I'd say definitely don't have a blanket ban so don't have a ban that says we will not, if you have a criminal record, we will not employ you. I think that's definitely don't have that. Do be open to the possibility of recruiting somebody with a criminal records history, but do your risk assessments so you've got that kind of audit trail, if you like, as some measure of protection should the worst happen and the person reoffend whilst employed by you. If you've done a risk assessment and you've kind of put measures in place or kind of can demonstrate why you didn't feel it was necessary to put any particular extra measures in place, then that's a good kind of protection for you going forwards. I think probably kind of linking it back into kind of what the government minister is trying to do. I think it's unlikely that any social landlord is kind of going to join these kind of positive, inclusive campaigns in relation to the employment of ex-offenders. So they've kind of got like Greg's and Oliver Bonas, etc., who are kind of open and willing to put their name to joining these programs. But I think it's unlikely that any social landlord would openly want to publicise that it was being that proactive in this space for exactly the sort of issues that we've been discussing on this call. I think it'd be a very brave landlord who kind of put their name publicly to an initiative like that. But they wouldn't necessarily be wrong to do so, but I think they would be brave.
I think at some point I'm going to do a roundtable on whether or not the social housing sector is brave enough, and I think that's a whole different debate. And I think it's one which I agree with you. I don't think they will, because I think too many people are worried about the what ifs, and I think that's a real shame, especially when we are in a sector where actually that amount of lived experience, particularly amongst some communities and some groups and things like that, would be invaluable to have somebody who's like, well, actually, I've been on the other side. I can connect with you in a way that maybe someone who came from a different background wouldn't be able to associate in the same way. And I think there is a huge missed opportunity there. It's interesting, as I say, that both Brian's point, Ted's point, and other tenants' points have come through saying, but actually, what about our safeguarding? Are we, who's keeping an eye to make sure that, people you're putting into our homes, people you're sending out to our homes aren't going to, act in a way that isn't that might cause reoffence or anything along those lines. And there is absolutely a balance to be had. And I think that's probably where the whole question, I guess, again, comes down to trust, not just trust in the individual, but trust that a business, if they are sending somebody out who has a previous conviction, whatever that might look like, have done their vetting checks, have done their safeguarding checks, have made sure and reference that the person they're putting and sending out to your home is safe for you. And most of the time it absolutely will be. But all it takes is that one story then. As you say, the problem is if a landlord does decide to be brave and say, actually, we're going to do a bit of a campaign on this, and then one story comes out of one time where something's up, then suddenly the entire process gets stigmatized, doesn't it?
Yeah.
Oh, just going to mute there. Are there any kind of other points you would kind of like to, when we're thinking about this? I think someone isn't on mute. I'm just going to go through and find out. There we are. Louise, lovely. So why does that keep unmuting? Apologies, everybody, if you're getting background noise. I'm trying to sort it. Bob's put in the chat, with Timpson's cutting house and car keys, is this not tempting fate?
Oh, in terms of them kind of so publicly and kind of positively looking to recruit ex-offenders, and now they're being handed people's keys. Well, obviously they've decided that that's not a risk, and I think they've there was a stat or kind of from an interview that I think possibly preceded Lord Timpson becoming the minister, where he something says like that out of whatever it might be, like over 1,000 ex-offenders that they've recruited, only 4 in that time had reoffended and well, I suppose had been caught reoffending and gone back to prison. But I think Timpsons are probably comfortable that you kind of take your keys in, but you're not disclosing your home address to. I mean, it's a long time since I got a key cut, so I don't know, but I don't imagine you're disclosing your home address or your vehicle registration number, such that a Timpson's employee could take that key and do something with it. So I think they're kind of probably comfortable from that perspective.
Yeah, I have had key cut recently, and absolutely they don't. The only ones they do is if it's a specialist type of key, they have to get certain details and it'll cost you a lot more. But the standard door keys, absolutely not. So yes, it's no one's asking for. I mean, car keys are different, but that's because often you have to get them sent to the manufacturer to do them rather than by Timpsons, unfortunately. In terms of then, just as a question before we kind of come towards the end of the session, while I'm still waiting to see if any more questions come through from our audience today. So if a current employee's criminal conviction comes to light, but it's been spent and it later comes out, where does a landlord stand in terms of trying to support somebody in that space? Not to say landlord, an employer more generally. So someone goes out to tenant's home, tenant knows that this person, be it through community or whatever, he has a conviction, but that conviction is spent in the landlord that never knew about it. Does the landlord have to, in any way, shape or form, act upon that? Is there any kind of safeguarding measures that then need to be doubled down on? I'm just intrigued from I think so much of what we talk about today, unfortunately, is stigmatization and fear and other things that kind of come underneath, well, what if someone's going to do something again? I think landlords, I'm sure, have been brash, and not just landlords, employers in general have been brash in the past, going, oh, well, you never told us. Well, you didn't have to. Well, it doesn't matter. You've broken some kind of guidance. Is there any legal ramification to dismiss someone or to, penalise someone who doesn't disclose a spent conviction during that process at all? Alert Call return as one of the keynote sponsors for the Social Housing Roundtable in 2025 into 2026, and we're delighted to have them back. Alert Call help as many people as possible feel safe, connected and informed by combining ingenious technology and award-winning human contact. As you can see from this touchscreen I've got with me, Alert Call's digital engagement solution helps social landlords proactively know their customers and properties by putting a portable touchscreen in every home, offering a daily property check through the optional OK Each Day service, plus repairs reporting, tenant surveys and much more. They also provide Beyond Warden Call, an easier, simpler and lower cost wireless warden call solution with video door entry, dispersed telecare and smoke alarms. Alert Call work with over 60 housing providers across the UK to enhance two-way engagement between customers and their landlords. In 2022, Alert Call won the Queen's Award for Enterprise and Innovation, and in 2023, Alert Call won Housing Supplier of the Year. We're delighted to have them back with us throughout the course of this year, and please do go check them out on social media and LinkedIn to find out more. Thank you very much, Alertical, for sponsoring us again.
Yeah, so if it was spent at the point of recruitment and they were going for a role that allowed them to essentially present themselves as having a clean criminal record, then yeah, they weren't obliged to disclose it. If their employer subsequently finds out through whatever means that they had a conviction, then really kind of it will depend upon how long that employee has been with the particular employer. So if the employee had been there for more than 2 years and the employer sacked them as a result of this kind of conviction coming to light, then the employee could pursue a claim for unfair dismissal for that. And when the Employment Rights Bill, a whole other kind of government agenda piece, is going to massively kind of bring that limitation period down to make it much easier to bring claims. But essentially that would be the route for the individual employee. If they lost their job as a result of a spent conviction coming to light that they never had to disclose in the first place, they would be able to pursue an unfair dismissal claim. And the employer, yes, might try and defend it on the basis of it was a breach of an implied term, or kind of customer perception is such that we can't continue to employ you. But essentially the employee would have good grounds because there's a statutory provision that says you're not supposed to take that into account.
And do employers need to have a policy or procedure written up that explicitly prevents discrimination against employees who have had a previous conviction?
They don't have to have one. I think some do. There's kind of a DBS code of practice that kind of tends to filter down, and you see employers adopting, which kind of just talks more about kind of being open to the recruitment of ex-offenders and then kind of confidentiality and storage of information, etc. But no, there isn't a positive legal obligation to have a policy that sets out your position on ex-offenders.
Okay, thank you. Brian?
One of the things which is just coming across to me is if somebody, for example, has a conviction for speeding, which sits on the record, I understand completely where you're talking about that risk assessment. Somebody who's had a speeding conviction is not doesn't pose a threat in any way or any sort of implication when it comes to repairing a tap. But if you've got this is where my question was coming from earlier, in that if you've had somebody who's had a conviction or barring orders or whatever in relation to domestic abuse, going into properties where that might be an issue, a lot of information which is gathered about tenants may indicate that that's what the vulnerabilities in that property are. And should an employer take that into account when, I suppose it comes down to the day-to-day working of allocating jobs in a way that doesn't happen?
So that might well be taken into account. So if that information about the tenant having previously experienced domestic abuse was kind of on their tenant file, then one of the safeguards that the landlord might have thought of when it initially vetted the employee, identified a domestic abuse conviction, one of the safeguards that they might put in place was, well, we will never send Joe Bloggs to a property where there is a flag on it in relation to a previous domestic abuse history. So that might be a safeguard that the landlord embeds that really no resident or tenant would ever see or necessarily be aware of, but it might be a safeguard that they've put in place behind the scenes to manage that sort of thing.
So how would the landlord then take that? I'm thinking about third-party subcontractors, because they have a duty of care to the tenants, which in essence goes across to subcontractors as well.
So I would I guess it depends on how much information on the tenant's file is shared with the contractor, because you can see a scenario where the landlord might, to kind of take your point to an extreme, where the landlord might want to say to the contractor, we need you to send somebody out to 17B Poplar Close. You must not send anybody who has a domestic abuse conviction, because the resident there has a history of having suffered domestic abuse. And actually that resident might not want that information shared down the line to the contractor. So I think there is, and it kind of comes back to something that Matt was saying, there is this kind of tension and balance that needs to be struck between information flow to ensure the kind of the best, or kind of the optimal way of protecting everybody in that particular scenario. So I probably can't say much more than that, because I am more employment focused than kind of like tenant law, housing management law focused.
I think, Brian, it's a really, really fair point. And it's certainly a difficult balance to try and reach, because how we make that work, I don't know. And that information and data sharing piece is absolutely key in all of this, because at what point, does a landlord have the right to tell a contractor that person 17B was once a victim of domestic abuse? That'd be something that we'll have to, I can certainly try and find out, but it's what are they then going to do with it? And then who knows, and how many people know, and how that data gets shared? Because I'm sure we all have things that we'd rather people don't know, but sometimes you might want, from a safeguarding perspective, just your landlord to know, or someone to know, and how that balances out, I don't know. The only question I still have for you, Kirsty, that was sent through, I've had a few that have come through kind of privately, so thank you to those who sent those over. Under what circumstances can an employer withdraw a conditional, how do you go about withdrawing that offer of employment? So if you find out that, I don't know, Mr. Z has a criminal conviction that goes against your own policy, and you've maybe tried to make it work but can't, how do you go about legally withdrawing that offer so that you then don't get yourself in trouble down that part of the line, as it were?
Yeah, so what I would tend to see employers do when they've kind of identified their preferred candidate is, as you say, make a conditional offer of employment subject to satisfactory references, satisfactory criminal records check, satisfactory immigration checks, kind of those standard things. And then if an employer has made a conditional offer on that basis, and then it does a DBS check and the result comes back which is unsatisfactory, i.e. it discloses a conviction which the employer is like, we've done a risk assessment, we really can't get comfortable with this, then the employee, the applicant, has failed to meet the condition. The offer can simply be withdrawn. No issue arises. The applicant can't claim that employment contract has come into effect that they've now been terminated from, etc., because they fail to meet one of those mandatory conditions, so the contract never comes into being. Sometimes we do see a scenario where the kind of recruitment demand might be such that employee has to start pending those checks being done, because sometimes there is, depending on the kind of level of check that you're doing, it can take, sometimes can take a while for the results to come back. So sometimes there might be a scenario where employment has already started pre that check result coming in, possibly with additional safeguards like Joe Bloggs, Mr. Z, whatever we're calling him, Mrs. Z could equally be a woman, can't kind of like go out to, can't be unsupervised or whatever pending that check coming in. But where employment has already started and then the DBS result lands and the employer is uncomfortable with it, then under the current legal regime, they could terminate the employment at 1 month in, 6 weeks in, whatever, whenever that result came through, with very limited legal exposure.
And obviously that's something that we're waiting to see change. So can't wait to see how that develops. Kirsty, a huge thank you. I've been very much kind of more of almost like a Q&A rather than a round table today, but really, really appreciate your insight, your thoughts and what you've been able to share. A huge thank you to Devonshires for sponsoring this session. Next week, we're back with Ben Moser. As I say, Elaine Middleton will be running that session for us. And we'll be discussing how we can unlock the private rented sector partnerships to help end homelessness. So a bit of a different discussion. It's going to be focused around that kind of that partnership work between private rented sector and the social housing sector. So I really hope you can join. But for now, Kirsty, a huge thank you to you for being part of today. Hope you found it useful, and look forward to catching up with everybody who was able to attend today in the future. Thanks again, and see you all soon.